You are listening to MyHRBuzz, brought to you by MyHR Concierge. Hosted by Chris Cooley, we'll bring you various topics and guests to shed light on the often confusing world of HR and also employee screening. We'll be putting the human in human resources.
I want to thank you for joining us today. I think we've got a great topic. We're going to talk about what employers need to know when they run a background check and that new hire or applicant actually has a conviction. So what do they need to do to make sure that they stay compliant? And so today we've got Bill Simmons with Littler Mendelson. One of the great things about Bill, he's actually our attorney for MyHR. Does a great job for us, but he focuses in this background check industry for both consumer reporting agencies such as we are, but also for employers. And so it's a niche and it's a great area, and there's not a ton of people that do that, or a ton of law firms that handle that. And so it's great that he can be here and kind of bring that focused expertise. So I appreciate you joining us today.
Thanks so much, Chris. Really appreciate being here to talk about one of my favorite topics.
Yeah. No, and so what is, we know that there's the Fair Chance Act, and there's a lot of things out there, both at, now it's at the federal, the state, and municipal level. So, can you give us kind of an overview of what that is and what employees need to think about?
Yeah. So I like to use the term Fair Chance Act, like you just said, to describe this subset of laws. Some employers still refer to ban the box laws, which still exist, but just to give you an example of why I make that distinction. For a long time, the trend was ban the box laws. And what that term refers to, as I know you're aware, but just for the audience, is that employment applications all the time, some still do, used to have a box where you had to check and say, check here if you've ever had a criminal record. And so the initial trend to help people who had criminal records before previously was to get that box off the application. And hence you had the ban the box movement. What we've seen, though, is now that trend evolve into what we now call the Fair Chance Act movement, where, okay, great, you're not asking that question at the application phase about criminal records anymore, but now we also want you to have a very robust procedure for how you look at applicants who have criminal records a lot more substantively. And that's what the Fair Chance Act movement is. And it's one of these trends in employment law where it hasn't fizzled out. So sometimes you see these trends in employment law, 5 jurisdictions pass something really quickly, and then it looks like it's going to spread across the nation, and then nobody passes any more laws like that. But Fair Chance Act laws continue to be a trend nationwide, and get into a little bit about why I think that may be. But this is definitely a big trend, and it's really important for employers to focus on. There's a lot of litigation, a lot of charges of discrimination based on these laws, and they have private rights of action just like any other sort of employment discrimination law.
Mm-hmm. Yeah, and one thing I would like to talk about just quickly that we get a lot of questions about is, when do you run that background check? Because we talk with employer after employer that want to run those background checks at the application stage before the offer, and we know that there are some regulations around that. So what is the right time or right that they need to run those background checks?
Yeah, the answer is somewhat simple if you want to have a 50-state compliant procedure, or a procedure that's compliant in a lot of areas. So if you're an employer who operates in a good amount of states or cities or across the country, pretty much it's post-offer. That's the only way you can have a uniform procedure. If you operate in just one state, then the answer could be potentially different for you, and that would depend on whether in that particular state, or if you just have city-based operations, that particular city restricts that ban the box law that we talked about, where you can't ask at a certain phase. Typically, there's 3 stages of where the laws break down. There's some states and cities where there's absolutely no regulations on this. Technically, you could still have a question on the application. Whether that's a good idea or not is a separate story, but you could still have it, and you could still run a background check early on. Some jurisdictions say you can only run a check and ask questions after an interview, like after somebody passes that first interview and they're initially qualified. But the real trend in most of the jurisdictions now say, no, you have to wait all the way until you found that applicant that you're making the offer to.
Okay. And I think that makes sense. And I know that's what if people ask us, what we generally say is wait till after the offer. And a lot of that's because now there's so many remote employees.
Yeah.
I mean, used to we would talk to a 20-man group, 20-man employer, and they're all in one state.
Yeah.
Whereas now that same 20-man employer may be in 15 states.
Yes.
And so just from a consistency perspective, that's always been our suggestion, is just wait until after the offer has been provided and then run your background check. That's the safest way anyway.
For sure. And it's, hey, it's worse for your background screening business. Hey, you're cutting down your volume, but you're right that it's far easier in my mind in a lot of these areas where there's so much legal complexity. The ability to have one procedure as best as you can really helps you avoid a lot of missteps. The more you try to vary it to push to the most aggressive the law allows in each various little jurisdiction, to your point, you just really wind yourself up in a knot, and it can be really difficult.
Yeah, that I agree with that. To me, I was told early on in my career, simple is generally better.
Yeah.
And so the more you can standardize it and have that consistency, the better. Just makes life simpler. And so, okay, so we've run the background check. If it comes back clear, it's not much to do. If it comes back with a conviction, what are kind of those steps that these employers need to think about?
So the truth with these Fair Chance Act laws, and by the way, I just want to say this too. This all started basically with the U.S. Equal Employment Opportunity Commission, which is the federal agency that's charged with enforcing discrimination laws across the country. In 2012, it issued guidance, as I know you're aware, Chris, on employer use of arrest and criminal records in employment. And that started the process of the idea of having to do some sort of individualized analysis of criminal records. And the idea behind the thrust of that EEOC guidance was that if you have too strict of background check rules, for instance, it was common at the time to say, nobody with a felony ever can have a job here, that you may disproportionately impact African American and Hispanic applicants. So that's the origin story of these Fair Chance Act laws, but the current statutes that are being passed get away from that because that was informal guidance. It depended on actually having a statistical impact on certain groups. The Fair Chance Act laws, once they're enacted, protect everybody. It doesn't matter their demographics. It doesn't matter if actually there's statistically significant impact on the practice. It just says you have to look at every background check individually and look at different factors related to those background check results. So when you get a background check result back that has a criminal record, the very first step in the analysis under these acts and under the EEOC guidance is to say, okay, we're not judging this person as a bad person because they have a criminal record.
Right.
What we do is we have to judge the criminal record as it relates to the actual job requirements. So is this criminal record related to the job at all? That's your first question. If you look at it and you can't really draw a connection between the criminal record and job, in today's day and age, you really just have to pass that applicant. It's not worth wringing your hands over. It's not worth worrying about, but I'm going to have somebody with a criminal record working in my workplace. It's just not worth it at this point. So that's your very first question.
And I think that makes sense because if it's if they're working in a different area, maybe they were doing money laundering and now it's more of a physical outdoor. Yeah. They don't have access to assets. Maybe there's something there. And goodness knows with the workforce that we have now, as far as the unemployment rates, a lot of times it's hard to find people. And so I know one thing too, that we need to look at from an employer perspective is when did it occur? So if somebody just did something stupid back when they were 19 years old, now if we get into violence and those things, that's different, right? But I guess those things need to be considered as well.
Yeah, it's a good point. So once you determine that a criminal record is actually related in some way to the job or job duties or safety, then you're right. The next question is, well, how long ago is it? Because what the EEOC and these Fair Chance Act laws are looking for is the underlying assumption is that in some fundamental sense, either the criminal justice system itself or through the passage of time eventually works to rehabilitate people.
Right.
That's the fundamental animating assumption behind the laws. And so the idea is, okay, once the conviction is related to the job, when was it? And more importantly is not just the time period, but what has the person been doing since? So I've had some crazy situations where if you just look at a criminal record, you might think, okay, this is job related, it's recent enough, we're just going to deny employment. We don't need to do anything else. We don't really have to look at this further. And I talk to the employer and I say, okay, well, I got it, totally get the reasoning, but what have they been doing since? Mm-hmm. And sometimes you find out that the position that they've been in actually objectively seems far more risky than the position they're about to occupy. So maybe, for instance, they're about to be hired as a bus driver. And the idea is, yes, but they're going to be dealing with the public. They have this assault record from 6 years ago. We're concerned. Okay, let's look at their job history. Well, the last 3 years they've been working at a daycare.
Yeah.
Now, again, nobody can force you to hire anybody at this point. But you at least want to know, especially with these Fair Chance Act laws that tell you directly to look at this sort of thing, what you're walking into if you still decide that you're not going to hire the daycare worker to drive the public bus out of the idea that they're still too risky from the conviction 6 years ago. You might still be right. You might have a good reason, but it's important to actually be able to articulate that you looked at that and here's why you still think the person's a risk versus just saying, well, I looked at the criminal background check for a few minutes, looked at it quickly, and just decided that nobody with this sort of offense will ever work here.
So how do they need to document that? Is that something that they need to write, put in a file? What's the best way to do that for them? Because obviously if this pops up, if they get a lawsuit in the mail 9 months later, they're not going to remember, or the person that made that decision may not be there anymore. And so what's that kind of process they would need to go through there?
Well, so part of the answer is governed by the law and part of it's HR practice. So in terms of governed by the law, there are a few jurisdictions, Los Angeles City, Illinois, New York City, and then Los Angeles County has a ordinance going into effect in just a couple of weeks here in September that require you to actually document the assessment and provide it to the candidate even during this pre-adverse action process where you walk through the background check with the applicant and give them a chance to respond. So in those jurisdictions, there's not really a choice. You have to document the factors. In fact, New York City even has a form itself that they provide and say this is the form that you should use. Same thing for Los Angeles City. They provided a form. Illinois is more open-ended. So that said, those are only a handful of jurisdictions versus all the way across the country. So that's where the HR practice that you mentioned comes in. And I was laughing a little bit because I have to have these conversations with employers. And it's always a little delicate because I don't want to say like, oh, well, of the team members on this call, some of you may not be here in 6 months. Right. So we need to document for that reason. But you're right. I mean, there's employee turnover. There's also, depending upon the size of the company, some folks who review the background checks may go through high volumes. And so then to come back and have to say, well, what were you thinking when you reviewed Bill Simmons's background check versus Chris Cooley's could be very difficult. So my overall personality as a lawyer is that I think documentation is better. And sometimes the push back that I get is, well, what if there's something bad in the documentation? What if somebody said something they weren't supposed to say? What if they made a mistake? My mind as a lawyer who represents companies and focuses on that is, I'd rather just know if there was a mistake. I'd rather know right away when I get the case, somebody made a mistake, or guess what, Chris, you considered a criminal offense that you shouldn't have in this jurisdiction. Then we just deal with it. Versus if you don't know and you're hoping for the best, and then in litigation a year later, the person's deposed, well, what were you thinking? And then it comes out that they had the wrong thought in their mind or made a mistake. That's worse because now you've wasted a bunch of time. It's always easier to say, hey, guess what, administrative agency, or guess what, plaintiff's lawyer, there's a mistake here. So-and-so made a mistake. It was against our policy. We've got good policies. Let me show you those. but this person made a mistake, so we'll get rid of this case. So I always favor documentation for all those reasons. The other reason I favor documentation, though, by the way, is that the Fair Chance Act laws are one thing, and they're definitely encouraging the employment of people with criminal records.
Mm-hmm.
And that's a laudable goal, and the cities and counties and states have a good reason for that. They want to get people not on state resources and with jobs and rehabilitated. But the truth is that the overwhelming majority of those laws also do not protect you for hiring somebody with a criminal record. And sometimes these decisions are not so easy.
Right.
And so sometimes the documentation is also equally important when you decide to hire somebody with a criminal record after you've gone through this back and forth process and it was a hard decision and they submitted mitigating information and you've decided to give them a chance, that you also show that you were reasonable in walking through that process. So that way, if that person, God forbid, does something and hurts somebody or whatever at work, that you're also able to say the same way, look, we were reasonable. We followed the local law. We went through the multi-factor analysis. We decided that this person was likely rehabilitated. We could not have possibly predicted that this bad thing would happen. So I think for that reason, too, documentation can be important, just to show you're reasonable.
Yeah. No, I agree with that. And as an HR guy and a former, accountant, that I'm all about that, right?
Yeah.
One thing too, I guess that's very important. Like we do a lot of multi-location companies, and so what happens there is a lot of times it's decentralized.
Yep.
So each location will run their own background checks, and then eventually they may have to make that decision. Maybe they run it up a tree, maybe they don't. So there's a lot of risk there. And so I know one thing that we suggest to our multi-locations, those that are decentralized like that, is we can systemically route background checks. So if it's clear, it runs back to that manager of that location.
Yes.
At that point, hire them and go. If it's one with a conviction, it can go to a different party that they define, and then they can internally make that decision. Now, they can't say what's on the report or not. What they can do is based upon our policy being the employer, they can say we will hire or not. So now what happens is you have your HR professional team making that decision versus your location managers. And so I guess that's a very important part, is who's actually making those decisions.
Right. And I've definitely had a lot of clients with a decentralized approach, and then also a lot that have gone more centralized over time. Typically, they tend to go centralized because some issues happen. Like you're saying, they realized that the site was having an issue with this. That can also be a good reason to have good documentation procedures too, because if you're just in the position that you just absolutely cannot centralize this process, at least if you have the same form with the same factors that somebody's got to write down and make sure they consider, it's a lot easier than just worrying about that local manager X has this view towards people with criminal background checks and manager Y has this other view. You get, hey, no, you got to go through this step by step. We want to see your work. It's like my kids in school with math, right? Like, show your work. But we do recommend, if you can, to have more centralized procedures and, a more focused team reviewing the results that can also bounce things off each other, because they're all constantly working on this area and learn through the process of doing these, because these are very difficult analyses, and you learn a lot more on the job, and the more that you do of them and the more that you talk it through with other people. And so for that reason too, it's really good to be centralized, in my view, if you can sustain it. The other thing that I do see missed when you're talking about sites versus centralization is that I don't think enough employers train the folks who will be on the ground regardless as to how to talk to candidates and managers about the background screening process. So even if you take the actual review out of their hands, the truth is they're still going to be the one who is the face of the company to those folks. Right. And even if it's just a quick do and don't guide, or a quick little flyer that you make sure that is in the possession of those folks to know what to say, what not to say around background checks, or when, to your point, when do you escalate something up the tree? When is there an issue on this can be really helpful. So for instance, I've had situations where even though the folks on the ground aren't reviewing the background checks, a candidate will self-disclose some criminal record to that person, the recruiter or the hiring manager or whatever. And one of two things will happen. Either the person will say, oh, that's no big deal. I'm sure we don't care about that here.
Yeah.
And then it turns out, yes, actually, we do care about that criminal offense. Or we'll say, oh, no, I mean, our policy is we never hire anybody with that sort of offense. So I think we should probably just end this here. And again, it's like, no, we don't have a uniform policy. We watched Chris's podcast. We know we have to do individualized assessments. But now this person has said something that can be attributed to the company that's actually contrary to what the view is of the company. So just having those quick things of, hey, if background checks come up, here's some key bullet points of what to say, what not to say, when to escalate.
Yeah, I think that's a great idea, because to your point, and the other thing is it does need to be written, because a lot of times at these, well, even if they're not multi-location, but a lot of times we all know there's a lot of turnover.
Yeah.
And so having those guides that they can take them through that process is invaluable. And that was another question I wanted to ask you as part of this. What about self-reporting questions? What liability there? Because we run into clients that will want to do that. They'll ask those questions. And I know there's some ban the box, and obviously, but even as part of the background check process, after they've already extended the offer, they've wanted them to do self-report. I mean, what are your thoughts on that?
So once again, part of it's law, part of it's HR best practice. Really unique requirement coming out of, just to use an example, the new Los Angeles County Fair Chance Act ordinance. It's going to go into effect in September. First ordinance in the country that I'm aware of that actually says you can't ask a criminal record question if you're going to run a background check until after the background check completes and after you give the results to the candidate.
Okay.
So you can kind of read between the lines there about what the goal is, right? The candidate already knows what's back on the background check before they have to self-disclose anything. But so that's interesting. That's a unique law though, but it's something to keep an eye on, where there may now be some more attack on criminal record self-disclosures. I was also, so stepping away from the pure legal requirements, kind of a middle ground here is that I was speaking with, on a panel, I don't know, about a year or so ago, with one of the lead lawyers who represents people with criminal records and sue companies for allegedly discriminating against them. And he was very honed in on the criminal record self-disclosure and trying to find theories to sue employers with that, about on the theory that if having too stringent of criminal record restrictions causes a disparate impact, his theory was that, therefore, also asking the question has a disparate impact, because even if you're relying on the falsity of answers to the questions, you can only have a false answer if you had a criminal record in the first place. Now, I think that's really strained, but I think it's meaningful when you're trying to set your procedures for how you want to do things, to just understand that some of the major advocates for people who have criminal records really don't like the question practice, and they're going to continue to try to come up with theories. Yeah. That said, in the country overall, it is lawful to ask that question, at least as of the time of the offer. And for some employers, it can make sense to do that depending upon how long it's taking for background checks to come back. And the jurisdictions involved. So you know better than me even that, there's certain jurisdictions that just decide to go haywire and decide they're not going to give background check companies information anymore, or they're not going to give identifiers, or they're going to cut their staff. And so delays can happen through no fault of the consumer reporting agency with public record sources. And sometimes then I have employers come to me and say, well, we've got these delays in a certain county, we're hearing it's going to take a couple weeks now to get all this cleared up. We really have people who need to start. What can we do?
Right.
And in that instance, it can sometimes be helpful to have a criminal record disclosure. So at least you can say, hey, we tried something. We tried something that we could do to see if this person was safe before they started work. But, to your point about, well, what kind of concerns come along with that, you do have to make sure that it's not just a generic question like, hey, anything we have to worry about on the background check, because jurisdictions also have limits on what sorts of criminal records you can ask about or not, or use or not during employment. So you can't just say, oh, our questionnaire practice is going to be asking people if there's anything we should be concerned about that might come out on the background check. It's got to be a very formalized process with the appropriate caveats.
Yeah. And I know we've always had concern because from the employer is that they may say something that legally could not come back on a background check.
Yes.
It may be outside of the limits. And then what does that leave the employer at risk? Because now they have information that technically from a background check they would not know because it's not allowed to be reported. And then they act upon that information. So that's always been a concern, a concern of ours.
You got to be really careful if you have something on a questionnaire that did not come back on a background check, that you definitely understand that in that jurisdiction, you're allowed to inquire about and use it, because it may very well be, like you pointed out, that it can't be used in that jurisdiction. So again, just the fact that somebody self-disclosed does not mean that it's okay to rely upon it. The other practical concern I have with employers using the criminal record question that I always vet with the employer before they start doing this is, do you actually have somebody there who is going to review the results on the self-disclosure before you proceed? Because it's one thing to have a questionnaire. It's another thing to have a questionnaire and not read it, because that's really setting the expectation up for the employee that, okay, I self-disclosed this. I guess it's fine because I moved forward in the process. And there's definitely been some unfortunate situations I've dealt with where the person self-disclosed, gets hired, 6 months later, a manager finds the form or HR finds the form and says, hey, wait a second, we can't employ somebody with such and such on criminal record. And that's a really bad situation because the person's like thinking, I disclosed this. Why is this a problem now? Plus, I've been doing a good job. It's just an unwinnable situation. So if you are going to have a questionnaire, you got to actually make sure that you're using it, you're looking at it. And then, by the way, these same Fair Chance Act laws that we're talking about that require the individualized assessment and process often apply just as equally to self-disclosed information as it does a background check report. And so you've got to know that too. You can't just say, well, this person self-discloses, so this is great. It wasn't on a background check. That means we can just immediately say, thanks for disclosing this. You're not getting hired. Nope. You still may have this whole individualized assessment process to do.
Yeah. And that's always, yes. Then that's always been our concern is what action do they take upon those questions? And then also to your point, do they read them? Because we've had clients that have these questions and either it's more of a yes, no question. If yes, then describe, and they just don't answer the question.
So you have a yes, but a blank and nobody follows up.
Yeah, things like that. So because there's just, to your point earlier, there's no training. There's, they're just trying to get a body in. And so, yeah, we've always had concerns on those. And I think the other thing that happens a lot of times is employers, when it comes to this point, may think their background check company does all this for them and to make sure that it's right, where really we can't do that. And so, I think it's up to them. It's up to that employer to make these calls and decisions, because obviously we can't make hiring decisions.
Yeah, that goes for both the criminal record questionnaire. The background check company can't deal with that, but definitely this whole trend of Fair Chance Act laws is directly to fly in the face of the idea that an employer can just hire a background check company and entirely outsource the process. And I would say at least once a week, I have a conversation with an employer and they say something along the lines of, well, yeah, I don't have to worry about that. The background check company handles everything dealing with the background checks. And I have to raise a big stop sign and say, look, we're talking about Fair Chance Act here. The background check company can't be handling this for you. There's no
Right.
way. The background check company is not filling out the New York City Fair Chance Act form automatically for you about what your concern is about the background check and what rehabilitating information the person submitted to you to discuss with you about it. And so it's really something that the very intent of the law, and this is really important to underscore, the very intent of the Fair Chance Act laws are to make it so that you have to do manual work and cannot just outsource, can't just make automatic decisions. That's the entire
Right.
intent of these laws. And so it's really important that employers have to keep their eyes on news involving the Fair Chance Act. This is not something where you can say, well, yeah, we've got a vendor for this. We don't have to worry about that new Fair Chance Act that was passed. The vendor can't do the assessment. And the other thing I wanted to mention, Chris, is the other disconnect I see quite frequently is, with these Fair Chance Acts, a lot of them say something to the effect of, you've got to have the chance for the applicant to submit rehabilitating or mitigating information. Basically, yes, my record is mine, it is accurate, but let me tell you more to the story, whether it's a story about what I've done since or story about what happened, what have you. That is also information that typically does not go to the background screening company. As you know, the background screening company handles disputes, and disputes are, my background check is inaccurate, my background check is incomplete. This isn't me, this is the wrong disposition, things like that. Since the background check company does not make decisions about employment, the proper place to direct those inquiries, for the most part, where somebody says, I've got something to add or I want to explain something, is back with the employer. And so we sometimes have situations where that's not clearly understood, so that the employer, as soon as the applicant says that they have anything to share about the background check, somebody at the employer is saying, oh, if you got something about the background check, you need to contact the background check company.
Right.
Then they go to the background check company and say, hey, I want to just share my story about this criminal offense. And the background check company says, okay, let me get this right. Are you saying the background check's inaccurate? Are you saying it's incomplete? No, this is me. This is totally accurate. Okay, you don't have any concerns about that? No, I just want to share my story. Okay, you need to go to the employer for that.
Right.
And now you have a situation where somebody's being ping-ponged back and forth because of just, again, a misunderstanding about the background check company's role versus the employer's role in this process.
No, I agree. And a lot of it's just education, which is one reason we're doing this podcast, is to try to make sure that employers know that they know there is risk if they're not hiring someone, and what they need to do to make sure that they protect themselves. And so it's just that education process. And so I think you're exactly right with that. And to be quite honest, a lot of those employers, because they don't know, that's the reason they're sending them back to that background check company.
I think the education is key. Just understanding these laws are out there. Again, nothing necessarily forces you to hire somebody with a record that you think really concerns you or is really related to employment. But what I always say to employers a lot of times now is hindsight's 20/20. So somebody can always challenge that you were unfair because you didn't give somebody an opportunity, or they can challenge that you made a bad decision and you hired somebody you shouldn't have who commits misconduct. So for that reason, the process and being able to say that you're reasonable and that you thought things through and you tried hard and you made a difficult decision is the number one takeaway. And once you do that, that's really the way to armor yourself against a lot of these laws. But you got to get there. You got to get to understand that this is really a requirement and it's serious. And train the folks that need to be trained to review the background checks to do that analysis.
I think you're exactly right. And I really appreciate you joining us today, because I think it's been really helpful. I think it's a lot of information. Like I said, it's a big educational process. We want to make sure our employers stay compliant, and we appreciate it. And so if employers have questions about background checks or maybe these processes or what they need to do, how could they contact you?
So you can look me up on Littler's website, littler.com, William J. Simmons. You see my name here. My phone number is always available. My office line is 267-402-3047. And my email is wsimmons@littler.com, Littler. Thank you so much, Chris. This has been great.
Perfect. Well, no, I really appreciate it. And I appreciate everybody that's listened and join us next time and we'll have some more great topics.
Thank you.
Thank you for listening to the MyHRBuzz podcast presented by MyHR Concierge. For more information on this topic and many others, please visit our blog at www.myhrbuzz.com. It's a free resource and has a lot of great information on HR and employee screening related topics. If you like the podcast, please do 3 things for us. 1, leave a review. 2, subscribe to the podcast. And 3, tell a friend. Our podcasts are available on iTunes, Spotify, and many other places where you get your favorite podcasts. If you'd like to provide ideas or feedback on future shows, send us an email at podcast@myhrbuzz.com, or you can reach us at 855-538-6947, extension 108. This is Chris Cooley with MyHR Concierge. Thank you for joining us, and we look forward to sharing more topics with you in the future.